How y'all doing? Daniel Gaines here. I'm gonna keep this somewhat brief. Just give y'all a brief update real quick on what's going on with things, because yeah, it's still going. I ain't done. They dismissed the dependency, as you seen in the last video if you watched it. I filed the motion for revision after Farmer maliciously tried to delay me receiving the signed orders to prevent me from being able to file anything against it. The revision hearing for that is actually tomorrow morning, 9 a.m. Washington time. It'll be through Zoom. I found out today, when I was finally given the Zoom information, that it's a female judge. And this is going to ruffle some feathers, but based on my experience and dealings in the state of Washington, the fact that it's a female judge means I've already lost this revision. Even though not a single legal reason will be able to be cited against me, and I'll prove it with the video tomorrow. They won't be able to cite a single fucking legal reason, but they'll still rule against me. They won't comply with the law. They'll further subject me to the deprivation of rights and conspiracy against rights and the violations of the RICO Act and all the other bullshit that I'm going to be bringing up in time. And when this judge rules against me, she and all the attorneys will then be given a surprise. I will make one final statement, and that statement's most likely going to cause every one of them, including this judge, to shit themselves right there on the spot. I'm not going to go into any detail right now, anyway, of what that surprise is. Watch the video tomorrow of the hearing, and if she rules against me, you'll know. It'll be the last comment I make on the record. If she does grant my request to set this over to the trial courts, then my surprise will just sit on the shelf. But it's to be determined by her actions tomorrow. However, when dealing with void orders, they really are limited in their legal options in order to comply with the law. So, seeing as this judge, as far as I'm aware, has never touched this case, we'll see what happens, because them putting a judge who's never touched this case on this case kind of makes me wonder if they're doing so just so that a way they can send it over to the trial courts and then claim sua sponte on it and try to mitigate damages for the state. Because at the dismissal, for the first time since last year when this started, over 15 months or so ago, Farmer actually acknowledged documents that I filed. She actually said she read my documents this time. She ruled against me and ignored the fact that it's void orders, but it's interesting that she says she actually read them this time when she's never said that before. It's interesting that she actually says she looked at my documents when she never has before. And what's even more interesting is not one time, y'all seen the video, not one time did anybody say anything or even try to argue that the orders are void. Not once. She didn't even argue that. She didn't make a comment about that or anything. All she said was, I have to do it in the proper courts. Incorrect. If you actually look at the Washington case law that I put in the document in my filing, it even states anytime, any place, so long as you're proper before the court. It doesn't say anything about you got to be in the right type of courtroom or anything. Anytime, any place is very clear. Anytime, any place. So, that being said, nobody was able to argue that the orders were void. I file the revision. Again, nothing's been filed against my document. Let's see, there's 3 attorneys, an assistant attorney general, which is another attorney, so 4 attorneys. There's a GAL, and there's a DCYF social worker. And then you have Faith, my daughter, and then you have Juliet, Faith's mother. Not one person, not one, has filed anything challenging the fact that I'm saying these orders are void. Not one person has made a single comment since I filed the document, since I was finally given access to and able to file the documents to prove it. Not one person has made a comment against it. Hell, on the child support side of things, because I did file in the child support court, just to strengthen this mandamus that I'm filing whenever they make their ruling. That's on the 28th of this month, next Friday. A week from this Friday is when that one is. I filed in that, and I assert in my declaration that's attached with it that the orders are void, and it's that simple. I submitted the documents to prove it. In Juliet's declaration, as she responded with, I'll show it to you guys later, tomorrow or something. I'll post a video and show it to you. But she doesn't even challenge the fact that the state of Washington lacked jurisdiction. All she claims is Melissa Roth was valid to serve documents. Well, that's because she's applying current law to a 2004 matter. See, in 2004, you had to be registered with the state according to the laws in the state of Washington. You had to be registered with the courts in order to effect legal service of documents. Melissa Roth was not. However, seeing as the documents that she's claiming I was served as a proof of service, the documents she uses as a proof of service, it lists a Louisiana address as where the documents were served at, allegedly served at. So, if she even put the documents were served on a Louisiana resident, that means that Louisiana law, as far as service goes, has to be complied with. Because you have to comply with the laws of the service laws of the state you're serving in, not the state the matter originates in. Louisiana law, as far as service, you have to be registered with the courts. You also have to live in the parish you wish to serve documents in. Now, parish might sound weird to some of you. Louisiana, because it was under French rule and everything, counties are called parishes. So a parish is a county. But you have to live in the parish you wish to serve in. Melissa Roth is a resident in the state of Washington and was in 2004, which means it was not valid, proper legal service. So the only thing Juliet claims in her document is that service was proper. She doesn't make a single statement about the jurisdiction issues or anything else. All she claims is service was valid. Which, no, it really wasn't under the law. But that's all she says. And then she starts talking about how Judge Johnson already changed venue, allowed for the change of venue to Mason County for custody. Child support never moved to Mason County. So, but anyway, I digress. I'm getting off topic. That's next Friday. Tomorrow, I'm hoping the judge will allow me sufficient time. Seeing as it's another female, this time an actual judge, not just a commissioner, I have my reasons to suspect I will not be given sufficient time, which means I will only be able to go into a few of the details about what's happened thus far. But wait till y'all hear some of this shit. Wait till you hear it. And it can't be denied or argued by them because the videos containing some of the worst of the things I'm going to state are already on YouTube. So, but yeah, I'll have a surprise for them tomorrow. Until then, I'll have a hearing video for you. But otherwise, y'all have a good day. Take care.